The Family Code provides ample provision for the protection of children who are or appear to be in danger. This video references the right of parents and others to file suit for protection of children, but the principal thrust of this video is to acquaint the viewer with the authority of governmental agencies to seize and otherwise protect children from abusive treatment. The relevant Family Code chapters include Chapter 262, Emergency Procedures in Suit by Governmental Entity, and Chapter 261, Report of Child Abuse. We'll also be referencing Title 4, Protective Orders and Child Violence, which is also included in this video as it occurs, in some instances, ex parte and other forms of relief and protection concerning children. There are a variety of Family Code sections concerning the right of parents and others to file suit for the protection of children. The authority of individuals to file suit include grandparents. Grandparents may file an original suit seeking managing conservatorship if there is satisfactory proof that the order sought is necessary because the child's present environment presents a serious question concerning the child's physical health and welfare. A parent and others, having standing to do so, may file lawsuit, including a motion to modify, to limit access of a parent who commits family violence, and they may seek to prevent the appointment of a parent as a possessory conservator because access would endanger the physical or emotional welfare of the child, or may seek to terminate the rights of a parent who is abusive or who endangers the child in accordance with the grounds provided in Section 161.001 of the Family Code. A child themselves, through a court-authorized representative, has standing to file suit as well under 102.003 subpart 2 of the Family Code. Family members of a household or other household, former spouses, and biological parents may initiate proceedings individually or through a county or district attorney in behalf of a child member of a household under the family violence provisions of Title 4. Any adult may file an application for Title 4 protection for the protection of a child member of a family or household, as can also the district attorney or the Department of Protective and Regulatory Services. Of course, family violence includes abuse of a member of a family or household towards a child of the family or household. A party in a suit to dissolve a marriage can include a request for a protective order in the petition, or can file the request separately under Code Title 4. However, once an order is entered, the case may be transferred to the court in which the marriage dissolution case is pending. A parent cannot appoint managing conservator if the appointment would significantly impair the child's physical health or emotional development. In determining whether to appoint a party as a sole or joint managing conservator, the court shall consider evidence of intentional abuse, physical force against a spouse, a parent of the child, or against a person younger than 18 years old committed within a 2-year period preceding the filing of a suit or during the pendency of the suit. A history or pattern of family violence may eliminate or seriously restrict visitation or access rights of the abusing parent. A parent shall not be appointed possessory conservator if the appointment would endanger the physical or emotional welfare of the child, and the court shall consider the commission of family violence in consideration of visitation privileges, if any. The court is not authorized to appoint a parent joint managing conservator if there is a history or pattern of child neglect or physical or sexual abuse by one parent against the other parent, spouse, or any child. A motion to modify managing conservatorship can certainly contain allegations which, if proven, would justify an emergency change of existing orders. Statutory allegations include such things as managing conservatorship should be changed in temporary orders because the child's living environment may endanger the child's physical health or significantly impair the child's emotional development. Or a motion to modify managing conservatorship may be filed within 1 year of the last court order when an affidavit is presented alleging facts that show the child's present environment may endanger the child's physical health or emotional development. An application for a writ of habeas corpus for the immediate return of a child can be defeated if the court finds that there exists a serious, immediate question concerning the welfare of the child. Any of the instances described can result in court orders to protect the child if the court finds that the allegations are of that degree of seriousness as to construe an emergency or endangerment to the child. A suit for divorce may also involve the family violence provisions of Chapter 71 of the Family Code. A suit affecting the parent-child relationship can include a temporary order attaching the child, taking the child into possession of the court, or excluding a parent from possession based on verified pleadings or affidavit. In addition, an individual may seek the protection of Family Code Chapter 71, family violence, whether or not suits otherwise have been filed. In summary, there are a variety of Family Code self-help provisions which a parent or other person can invoke if they believe a child is in danger, and which can be brought to the attention of the court immediately or even on an ex parte basis. Reporting of child abuse. Generally, there are instances when a child is being physically injured or otherwise abused, or the possibility of abuse has been reported, and it's necessary for a governmental agency or child protection unit to investigate or intervene in behalf of the child. This can occur in any number of circumstances, usually when an agency is contacted concerning a suspicion of abuse or report of abuse, perhaps reported by a parent, teacher, doctor, or other person. Family Code Chapter 261, including professional persons, have cause to believe that a child's physical or mental health or welfare has been or may be adversely affected by abuse or neglect to report that circumstance. They must report it to any local law enforcement agency, Department of Protective and Regulatory Services, or if the allegations concerning a licensed or registered facility, the report shall be made to the state agency that licenses or registers that facility. The code specifically defines professional to include any individual licensed or any employee of a facility licensed, certified or operated by the state, including teachers, nurses, doctors, and daycare employees, and employees of a clinic or healthcare facility that provides reproductive services. The failure of a person to report suspected abuse or neglect is a Class B misdemeanor. An employee who reports suspected child involving an employer, for instance, a daycare center, is protected from retaliation from the employer for reporting abuse. The terms abuse and neglect are defined under 261.001 of the Code and are sweeping in their definition, including any kind of mental, emotional, or physical injury or neglect, whether by act or admission of a person, including the child with involving the child with alcohol or controlled substances, and includes a person who fails to prevent the abuse or neglect by another. The records and reports developed in the investigation are confidential with certain exceptions, for example, adoptive parents. Anonymous reports are also to be investigated fully if there is some evidence to corroborate the report. Failure to report suspected abuse or neglect is a Class B misdemeanor. The failure to act upon reported suspected child abuse may create a tort liability. In the case of Golden Spread Council versus Atkins, it was held that the Scout Council may be liable for having breached the duty of reasonable care in recommending a person as a potential scoutmaster when it had received some information of suggested sexual abuse of a child by that person. In Perry versus SN, a case involving child abuse at a daycare center, it was held that failure to report child abuse is not negligence per se. If the opinion of the investigators is that immediate removal is necessary to protect the child from further abuse or neglect, the child can be removed from immediate danger before or after the filing of a suit, as provided in Family Code Chapter 262. If the investigators have reason to believe a parent of the child may remove the child from the state before the investigation is completed, A district court, after hearing, may issue a temporary restraining order to prevent the removal. A person reporting or assisting in the investigation of a report of child abuse or neglect is immune from civil or criminal liability unless the reporting or assistance was done in bad faith or with malice. A person who intentionally makes a false report that lacks factual foundation is guilty of a Class A misdemeanor. A second offense is a state jail felony and may be grounds to restrict access. The fact that a party has falsely accused the other party of abuse is admissible in any suit between the parents involving terms of conservatorship, and if the court makes that finding, the court shall impose a civil penalty not to exceed $500. A frivolous suit for damages filed against a person reporting abuse or neglect would entitle the person being sued to recover attorney's fees and other expenses related to the defense of the claim. Customarily, a child will not be removed from a person entitled to custody or possession until there's been a complete trial on the issue. Family Code Chapter 262 provides the exception to the usual rule when children are found to be in danger. A governmental entity, often the Department of Protective and Regulatory Services, may take possession of a child based on a petition, an affidavit, and resulting court order where there is immediate danger to the child. In some instances, temporary possession of a child may be taken without any court order. Often court action is taken as a result of an investigation concerning reported child abuse or neglect, or the seizure of a child may be instantaneous as a result of a report and before an investigation can be started or completed where the facts require immediate action. Because the seizure of a child is an extreme remedy and may be very traumatic to the child as well as to the parents, Family Code Chapter 262 sets out quite specific rules covering the taking of a child and the requirements for court hearings on the issue. In the event that a child is removed from the possession of the parents and the Department of Protective and Regulatory Services has an affidavit of relinquishment or has been named managing conservator, the family court requires the court to conduct a periodic review of the conservatorship appointment and the department's placement of the child. Additionally, the department is required to file a service plan concerning the child, detailing the goals the department has for the child and the responsibilities of the parents concerning these goals. The service plan itself is subject to periodic review by the court. All is set out in Family Code Chapter 263. Formally, a Child Protective Service case might continue for 2 or more years while a decision regarding termination of parental rights was considered by the investigation agency and court system, leaving the parents and the child in legal limbo for perhaps a year or more, and much time would pass before a decision to file amending pleadings to include a termination pleading would be filed after it appeared to the agency that the parents would be inadequate care providers. This, of course, might keep a case pending, sometimes for several years, before a termination decision could be concluded by a court or jury. In order to expedite the legal process concerning these children, to speed up either the return or termination and perhaps adoption of the children, the legislature set certain time limitations in place, requiring Child Protective Services and court system to make timely decisions and eliminate unnecessary delay. Generally, with certain exceptions, a final decision concerning the child must be made within 1 year of the date the state agency is appointed temporary managing conservator, or the child will automatically be returned to the parents. In response to the abandonment of newborn child in unsafe places by a parent who did not want the child, the legislature passed the Emergency Possession of Certain Abandoned Child Act. Rather than leave a child in a dump area, the porch of a stranger, or other place where the child might be found, a parent now has the choice of invoking the provisions of this act. A designated emergency infant care provider can take possession of a child without a court order if the child, who appears to be 60 days old or younger, is voluntarily delivered to the provider by the child's parent who expressed no intent to return for the child. Generally, the care provider cannot detain or pursue the parent and has no legal duty to ascertain the identity of the parent, who may remain anonymous. The Department of Protective and Regulatory Services shall take possession of the child. The abandonment of a child under these code provisions constitutes grounds for termination of parental rights. When a suit affecting the parent-child relationship is brought by a governmental agency, a temporary restraining order or attachment for a child cannot be issued by a court until there's been a full adversarial hearing, unless the court is satisfied and finds based on a sworn affidavit that 1. There is an immediate danger to the physical health or safety of the child, or the child has been a victim of neglect or sexual abuse, and that continuation in the home would be contrary to the child's welfare, and 2. There is no time consistent with the physical health or safety of the child and the nature of the emergency for an adversarial hearing, and reasonable efforts were made to prevent or eliminate the need for removal of the child. The affidavit must be sworn to by a person with personal knowledge and shall state the facts relied upon, which would satisfy a person of ordinary prudence and caution that there is an immediate danger to the child. In considering whether there is immediate danger to the physical health or safety of a child, the court may consider whether the person who has possession of the child has 1. Abused or neglected another child in a manner that caused serious injury to or death to the other child, or 2. Sexually abused another child. If the court finds that family violence is involved, the court has the authority to issue an order under Chapter 71. A temporary restraining order or attachment of a child issued under this code chapter expires not later than 14 days after the date of the issuance, unless extended as provided by the Texas Rules of Civil Procedure. If there is no time to obtain a temporary restraining order or attachment consistent with the health and safety of the child, a representative of the Department of Protective and Regulatory Services, a law enforcement officer, or a juvenile probation officer may take possession of a child without a court order under the following circumstances. 1. Upon discovery of a situation where the child is in danger, the child is delivered to the person entitled to possession. A lost child would be an example of this circumstance. Upon voluntary delivery of the child by the person entitled to possession of the child. Upon personal knowledge of facts leading a prudent person of caution to believe that there is an immediate danger to the physical health or safety of the child, or that the child has been the victim of sexual abuse. On information furnished by another and corroborated by persons knowledgeable of facts which, when taken together, would lead a prudent and cautious person to believe there is an immediate danger to the physical health or safety of the child, or that the child has been the victim of sexual abuse, and there is no time to obtain a temporary restraining order or attachment for the child. If the child is voluntarily surrendered or delivered to a governmental agency by virtue of the second item that we mentioned, suit shall be filed not later than 60 days after the date the child is taken into possession. If the seizure of the child was by virtue of other items, a suit affecting the parent-child relationship may be filed without unnecessary delay, and an attorney ad litem and a guardian ad litem shall be appointed for the child, and an initial court hearing shall be held the next working day. However, if the court is unavailable, a hearing shall be held no later than the third working day. If suit is filed by the Department of Protective Services seeking termination, the suit must be filed within 45 days from the date the department has taken possession of the child under Section 262.0303, which concerns an abandoned child. The initial hearing may be ex parte, and proof may be by sworn petition or affidavit if a full adversarial hearing is not practical. If no initial hearing is held within the time required, or if the court at the initial hearing is not satisfied that there is a continuing danger in returning the child which was taken without a court order, the child shall be returned to the person entitled to possession. Of course, the court is not required to return the child if the evidence shows that the child has been the victim of sexual abuse and there is a substantial risk of future sexual abuse. Continuation of the child in the home would be contrary to the child's welfare. Reasonable efforts were made to prevent or eliminate the need for the removal of the child. In determining whether there is a continuing danger, the court is entitled to consider whether the person to whom the child would be returned has sexually abused or otherwise abused or neglected another child so as to cause serious injury or death. When an agency takes possession of a child, notice must be given to each parent or to the child's conservator or guardian, advising them of the reasons the child was taken, whom they may contact for information, a summary of their legal rights, and advising them of the right to hire an attorney. Generally, unless the child has been returned to the person entitled to possession, and unless temporary orders, if any, have been dissolved, the court is required to conduct a full adversarial hearing within 14 days after the child was taken. At the conclusion of the hearing, the court shall return the child to the person entitled to possession unless the court finds sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by any act or failure to act of the person entitled to possession, and remaining in the home is contrary to the welfare of the child, and there is substantial risk of continuing danger if the child is returned home. In making that determination, as with the initial hearing, the court may consider whether the person to whom the child will be returned has sexually abused or otherwise abused or neglected another child in any manner that would cause serious injury or death. If the court finds that the custodial parent is not appropriate for placement, then the statute gives the custodial parent a preference over others. At these hearings, parents are entitled to be warned that the parental rights and duties may be restricted or terminated unless the parents are willing and able to provide the child with a safe environment. If appropriate under the evidence, temporary orders may be entered as provided under Chapter 105, at which time the court is also required to determine the court of appropriate jurisdiction and transfer the cause if necessary. A motion to transfer when this type of case is filed is timely if made at any time. The Code provides that in cases filed by the Department of Protective and Regulatory Services concerning an abused or neglected child, the court may order that, with the consent of all attorneys, the testimony of a professional be done by video conference, which would usually preclude the necessity of appearance in court. The term professional is defined as being those persons listed in 261.101b and is an extensive list of licensed or state-certified individuals. This statute would appear to be one to accommodate the professional rather than one which expands the rights of the rules of evidence. In instances where the Department of Protective and Regulatory Services or other authorized agency has appointed a temporary or permanent managing conservative of a child, the Family Code in Chapter 263 provides for the periodic court review of the child's placement, service plans designed to define goals for the placement or return home of the child, and other review hearings. The court is authorized to continue the appointment of the attorney ad litem or guardian ad litem at any period set by the court. Historically, the state agency concerned with child welfare attempted to follow the state policy, which was to make every reasonable effort to create a service plan and to work with the family, involve mental health professionals and others in an attempt to put the family unit in such condition as to be able to return the child. Unfortunately, this effort sometimes involved several years and ended unsuccessfully. In an effort to expedite the correct placement of children, the legislature mandated certain time limits, generally 1 year, after which a permanent placement or return of the child to the family would be required. All is provided generally in Chapter 263. In some instances where this effort is clearly unsuccessful or inappropriate because of aggravated circumstances, the court is authorized to accelerate the trial schedule and bring a final resolution for the child. The court is also given some limited latitude where the child has in fact been returned to a parent and the circumstances requiring monitoring. Thank you for watching. If you need more information on child abuse issues in the state of Texas, or if we can provide any services for you, please contact us at thepalmerlawfirm.com.